Welcome back, everyone. It is now time to begin the Wisconsin Real Property Listers Association panel discussion. I'll just mention real quick again, reminder, this is part of the WLIA. Please follow the WLIA Code of Conduct. Please mute your mic during presentations. And if you haven't already, add your name onto Zoom so that we know who you are. All right, let's get this going. So, Nicole Hoeppner from Dodge County is our Education Committee Chair and has done an excellent job twisting the arms of some of our other members to sit on this panel, as well as compiling a small list of starter questions. I'm very much hoping we will not get through all those starter questions and that we'll have plenty of questions from the audience that we will not get to the end of our list. Also joining this panel from our Education Committee are Aprill Flores from Oconto County and Britta Kelly from St. Croix County. As of 20 or 30 minutes ago, Britta Kelly is now the president of the WRPLA, which means I am no longer that person. Joining us from Trempealeau County is our favorite chicken farmer, Nick Gamroth. Nick is also currently one of our WRPLA's representatives to the SLF committee, the state local finance, if anybody is not aware of that. Joining us from Lafayette County, sometimes known as Lafayette Country, if you were at a PLSS meeting last year, you'd get that, is Krista Zettle, who is currently our primary representative to the Joint Alpha Committee and was the president of the WRPLA in 2018. Joining us from Dodge County also is Dave Addison, who represented the WRPLA for many years on the WLIC and the SLF, as well as serving as WRPLA president in 2005. Last but not least, joining us from Jackson County is our newly elected president-elect, Aprill Schoolcraft. If you're just joining us now, my name is Brannick Beatse. I am the real property lister from Monroe County. For the past year, I have had the privilege of serving as the Wisconsin Real Property Listers Association president. In case any of you are not really sure what a real property lister is or does, allow me to answer that question before we get on to any others. At the core, a real property lister's duty is to make sure that there is an accurate listing of land ownership so that when it comes time to send out the tax bills, landowners can be taxed for the lands that they actually own. In all cases, this involves reading deeds recorded in the Register of Deeds office, determining whether a valid conveyance has taken place, and changing the ownership records for all valid conveyances. There is someone who performs these duties in all 72 Wisconsin counties, as well as a handful of cities that take care of their own property listing. With some variance in procedures, duties, differences in local ordinances, and some differing opinions, there are many questions where you would receive a variety of different answers from different listers. The WRPLA was formed in 1952 as an association of peers to help listers keep abreast of the newest information coming from the state affecting our job duties, as well as to be a place to discuss amongst ourselves the ins and outs of what we do in hopes of improving the way we do our jobs. We are not a regulatory organization, and we do not set any rules to abide by in the performance of our property listing duties. Our panel will do its best to answer your questions and explain where the answers are coming from and perhaps where variance is to be expected from county to county. For this panel discussion, we do have a few prepared questions to fill in dead time or to get you thinking, but ultimately we are depending on you, the listeners, to give us some questions to answer. I would ask that everyone besides the panel stay muted, and anyone with a question, please enter the question in the Zoom chat. As moderator, I will be monitoring the chat and selecting questions to ask the panel. With that, we will go ahead and get started. Oh, I've already got a question. All right. So I've got a question from Lori. A guy put up a fence in the right-of-way in 1970. Now he wants to claim adverse possession because the city wasn't to extend the sidewalk. Can he? Follow. Oh, go ahead, Dave.
No, I was just going to mention, I don't know that you can adversely possess against a governmental body. That's my answer.
I agree with Dave. You can't adversely possess government-owned lands, so I say no.
Follow-up, can the city claim eminent domain to force the sidewalk?
Yeah, I mean, I would say yes if there's a question on it. I mean, that's the eminent domain is definitely an avenue that they could pursue.
If the sidewalk is going to be in the right of way of the city's street, the city has all the rights to put that sidewalk there.
Yeah, and these are kind of lawyer questions, so we're not really the people to ask, but we do deal with this, so we have our answer. And lastly, if the fence was on a neighbor's property, can he claim adverse possession?
So if it was on a neighbor's property, yes, you could claim adverse possession. But the thing is, with adverse possession, you actually have to go to court to get it ruled upon by a judge in order for it to change any records in the treasurer's office on the tax roll, the things that we list. So you can't just come in and say, I own this, can you put this on the tax roll in my name? We won't list property that way.
Thank you, Krista. That was very concise, and I would agree. All right. Nicole, do you have the list of questions? Do you want to move on to question one?
I do. I will. So I want to start off by thanking everybody for joining us today. Hopefully we can make the most of the hour that we have here to give you all a brief look into what we all do. So with that, I'm going to start with our first question. So what type of professional background do real property listers have?
Krista, do you want to go ahead and answer that one?
Sure. So the Wisconsin Real Property Listers Association is actually a very diverse group of individuals. And if you were with us during our business meeting, you've just now noticed that our diversity grew with the introduction of some new members. We have, people who can chase down bears and coyotes, and we even have a former police officer. But like Brannick said, we aren't so much a group that regulates our members as much as a group that will bounce questions off each other to gain kind of like a best practices consensus amongst our members. That being said, we have listers who come from all types of professional backgrounds. We have the title industry, the GIS world, planning and zoning or other county departments, surveyors, banking. We've even had an attorney, and we have people from, the legal world. Each property lister is unique in each county, and that's based not only on those various professional backgrounds, but also where the lister is housed in the county, because each county has a different property lister in a different place and assigns them different duties. So some you can find in the treasurer's office, the register of deeds office, the planning and zoning office, the land information office, and some are even lucky enough to have their own department. But because of that, there's really no hard or fast rule about who can be a property lister or what kind of professional background you need to join us. But that is what makes us such a diverse group, and we are a great resource for other listers. So once you do become a lister, we have our Bitrix format to be able to communicate with each other within our group. The one thing that is the same throughout all of the property listers is if you don't know who your property lister is in your county, you should figure it out, because we are a wealth of information. And if you don't know that yet, we're hoping that at the end of this panel discussion that you will realize what you've been missing. And one of the things is that to list property accurately, we have to know a vast array of components. And so if you ever have a question about property in your county, start with your real property lister, because I bet you 99 out of 100 times, they can answer your question and you will not be passed around your county from time to time to department to department. So get to know who your property lister is. We are a very vast group of diverse people, and we're actually pretty great.
Thanks, Krista. I think that was a really good introduction to what we all do. I like the part where, you know, basically the buck stops with us. If we can't answer your question, we know who you need to talk to and we can get you that information. So thank you for bringing that up. That was well said. So that kind of segues into our next question, which is, who do you typically interact with?
So I'm going to take this one because I want to be done talking and, you know, leave it to the rest of you because I'm an introvert. So we interact with a lot of different people, taxpayers especially, other county departments, municipalities, assessors, the Department of Revenue, title companies, all those kind of things. And like I said before, each property lister is in a different department and has different duties. So it's going to vary from county to county, but statutorily, what we aim to do is to list and maintain accurate ownership and description information for all parcels of real property in the county. And that's, we're listing property information for the purposes of taxation and assessment. And that's per statute 7009 of the Wisconsin state statutes. So this will include things like the owner's name and an accurate legal description that is shown on the latest records of the Register of Deeds office. So thus we work very closely with the Register of Deeds offices in our counties. And notice that I said recorded documents. Now, Wisconsin is considered a race notice state. What that means is that while a conveyance doesn't need to be recorded to be legal, it has to be, in Wisconsin, recording a deed is a form of constructive notice. So what that means is it is available for viewing by any member of the public. So any problems that arise from the issues of ownership, possession, and title, those are all things for the courts, but we are listing what is of record, and that is our job via 7009. Like I said, we're mainly listing for taxation purposes. So of course we work very closely with the county treasurer's office since they are the ones who will collect the taxes based on the information that the property lister is creating. Some property listers are even the ones who create and print and send out the tax bills in their counties. It's not actually just specifically a treasurer's office duty. During the year, we work with each local municipal assessor to update the values for property each year. And we also provide the notice of assessment that is sent to the taxpayers to notify them of any assessment changes. We also are in contact with the municipal clerk because we provide them their official assessment roll for the year. And then during the process of open book and border review, we are in contact with them and the assessor to make sure that any changes they make get reflected on the county level so that when tax bills do go out in December, they reflect the correct assessment value. Then we file the statement of assessment on the behalf of each of the local clerks so that the Department of Revenue will be able to do their calculations for later on in the tax year for manufacturing and creating aggregate ratios. Also, the tax parcels that we create in our assessment role are generally used as the basis for mapping in the county. So we work with a lot of other departments like GIS or zoning. We work with surveyors. Some property listers, such as myself, actually maintain the tax parcel layer in the county's GIS. So that helps me quickly identify and catch any legal description discrepancies, and I'm able to facilitate the correction of that information. So then you'd reach out to title companies and attorneys, anybody who has been involved in creating a document that's been recorded, and then we work to get addressing those issues to get them corrected of record. And we also work with people who work with the addressing, the NG911, and any kind of zoning or code administration for creating permits, people who need to use our parcel numbers. We are the ones who create the new parcel numbers for any new property that is created. So we are in charge of that, and we will, you know, work with your other departments to make sure you have the most updated information. So yeah, we work with quite a few people.
Thank you, Krista. Just to reiterate, if you have any further questions, please post them in the chats. We will try and get to, I'm hoping to get to more questions asked from the audience than our pre-prepared questions. That being said, Nicole, do you want to read off the next question?
Yeah, I'll unmute myself. Yeah, thanks again, Krista. That's really hitting the nail on the head here. We're really, we can't stress this enough. We're a diverse group of people. We come from all different sorts of backgrounds. And I would just like to note that I think at our 2018 annual state meeting, we did a poll of people who you know, just to see how many years of experience you have, and came to find out that there's 6.5 years on average per person. So that's, you know, anyone who started in 2014, 2015, you're the average. Aprill, myself. So yeah, it's just, you know, and you kind of learn as you go. So there's a lot of things that you pick up on the way, regardless of what your background is. So you learn a little bit about everything involved in the job. So with that, I'm going to move on to our next question. It has to do specifically with the assessment process. So what is the real property lister's role in the assessment process?
I can take that one.
Okay.
All right, so what Krista really did just now is she nailed it on the head. But if you don't believe her, you can look up 7009 in the state statutes and see it for yourself. It's real short. I know none of us really like to look at them, but it is right there. It's black and white, but most of the work is in the gray. There's a lot of gray there for us. And each county or municipality is different, where we might also be housed in zoning. We might also be housed in treasurers. We might be in our own little area. It doesn't matter. I kind of like to think of the property listers as this funnel. So there's this huge funnel with all these questions and things. And it all comes down, like if somebody doesn't pull it out of the funnel quick enough, it comes to us. And then we just kind of figure out what to do with it and either pass it off or we deal with it ourselves. So we try to be helpful. For the assessment year though, I've learned so much about this. I didn't really, when I started, know anything about real property versus personal property. Like what does all this mean? You learn on the fly. If you have questions, don't feel dumb. Just reach out and ask, because I'm sure that every one of us had the same questions at one point. And so I'll start with the beginning of the year and run straight through the calendar the best that I can from my aspect. So if you have any questions, just write it in the chat, raise your hand, unmute yourself, yell on top of me. I don't care. It's okay. I promise. My feelings won't be hurt. Okay. So Wisconsin's local assessment year runs from January through December, and with data and reports being released throughout the year, such as MFL or managed forest law listings, manufacturing assessment role and values, because the state does, there's a category called manufacturing, and they decide what is manufacturing, what's not. So if the state picks it up, the local assessor does not, and vice versa. So that's constantly, well, not constantly. Sometimes it flip-flops and changes, so you have to be aware of that. TID and TIF districts, any kind of other special districts that are out there, that's also a list that's coming through. Referenda and resolutions and annexations, those are all things that we have to deal with and we have to be aware of, especially during tax bill printing. So our elections are in November. Well, all this stuff is rolling in, we'll get there, but all this stuff is rolling in. Sometimes you vote on a school referendum or a municipal resolution, and if there's no sunrise or sunset date on that, it might be like immediate that we have to put that on the tax bill for that current year. That's a lot of fun. Okay, so pay attention. We need to stay on our toes to help keep those tax bills correct. In turn, we also have to release reports and data throughout the year, or we're going to hear about it. If we're late on something or if we drop the ball, we're getting emails, we're getting questions. And let's see, besides this, oh, yep, what does it look like? Here we go. January to February, we'll start there. Listers might seem hard to get a hold of in the beginning of the year. It can be a bit of a whirlwind. We're not being rude. We really want to help the public. It's just really kind of busy. We're processing remaining documents from the previous recorded year through December 31st. And often we'll see a spike in recorded documents toward the end of the year in the Register of Deeds, as many owners are aiming to get their business taken care of under the wire so that they can start fresh for the next year. Understandable. Assessors want their boots on the ground immediately as soon as they possibly can to capture a snapshot of an assessment year or assessment snapshot of the beginning of the year of that property. Like what's going on, what was the phase of it, what's actually on it, what's not on it. And we do our best to get the assessment work rolls out to them by mid to late January. I'm still working on that. I don't think I've ever released anything in January. And I'm sorry to my assessors, and I always tell them I'm sorry, but I'm just doing the best I can. I haven't been fired yet. That's okay. And my assessors keep coming back and being cordial, so that's okay too, I guess. We may also provide the following to the assessors. Owner change labels, and legal labels, they might call them gum labels if you have an older assessor. I didn't know what that was. I just saved all my gum wrappers for them. No, I'm just kidding. Split conveyances, those are for me. I make a bunch of packets so that there shouldn't be any question as to what's being split, what's not. Exempt, not exempt changes, surveys, new addresses, and permits, and a bunch of other stuff I'm probably forgetting right now. So just want to remind you, if there is something on this chat bar, I'm not watching it. I'm watching the camera. So somebody interrupt me, like Brannick or Britta, anybody else, just, okay, I'll carry on.
We'll go on to a new question once you're done.
Oh, okay. All right. So I'm going to skip a little bit here, but you're going to kind of ask, well, how many phone calls really come in? So tax bills are mailed out to the owners between the end of November and the end of November, the end of December, hopefully in a normal tax year. Tammy, I'm sorry, Grant County, she's got some situations going on where they're not even going to have border reviews until December, and that's going to stink, and that sounds terrible. But phone calls will come in steady. And what are they regarding? So sometimes these are the pertinent ones to the tax bills, not all the other stuff that we also get. But why did I get a tax bill? I sold my land in December. Well, you sold it after the tax bill was printed and sent. Why didn't I get a tax bill? I bought land, part of a parcel in 2020. Well, the assessment roll snapshot that parcel parent, you're not going to get a tax bill at the end of the year until you tell your lister that you want a split bill, or however your lister decides to handle these things. Some counties and municipalities don't even do split bills. That's great. That sounds nice, but there's some that do. And so if a parent parcel is, let's say, this is the easiest, a 40, and you split 10 off, if your zoning and subdivision ordinance allows, by survey or whatever. And now that child parcel is the 10 acres, and the remainder 30. I'm not really good at math, but that bill will just get split. It's just on face value for that first year that it's split. The next year, everybody gets their own assigned assessment, and it'll be normal. So there is a little hairiness in split years. You can ask later on that if you want. I'll try to explain it a little better, but another question we come in. I've changed my address. Where did my bill go? Just change your address with the county, make sure that they know where the bill goes. The tax bill is wrong. Usually it's not. And you kindly have to, well, you don't have to, but you could kindly take that caller, and usually they're elevated and angry. You can take them through and kind of go through the process and explain and educate if you have time. I know it's busy. And just kind of defuse this caller, and then they might walk away being like, you know what, thanks for taking a little bit of time out of your day. I understand it a little better now. Thanks. It happens sometimes. Another question is, I wanted a bill split. Now what? So call your treasurer and have your closing paperwork ready, have written payments agreements ready, have maybe your title company look into it. And if all else fails, they have every right to request a split bill. Usually it's from the local municipal treasurer. It's state statute 70.323. So if those calls come in to the local treasurer, like the town or village or whatever, usually they kind of land on our desk because that's what we do. So, or the treasurer, the county treasurer's desk. Yes.
Don't they have, if they want a split bill in the year that the division occurs, don't they have to submit it in writing to the treasurer as a request?
Yes.
Okay.
But it doesn't have to be before the bills are actually printed.
A time frame too, isn't there? They have to request the bill in writing within a certain amount of time before the bills go out.
I don't know. I got it right here. Hold on. Share
No.
screen.
Oh.
Can I share the screen? I don't know. I'm sharing the screen. Oh, is that my screen? I'm sorry. Fail. Is it this one?
Aprill, while you're doing that, I'm just going to interrupt and mention that we did get a in the chat is a statutory reference supplied by Brian about adverse possession not being possible against government entities or subdivisions thereof. Just FYI.
Thank you, Brannick and Britta and Brian. Okay.
It does say in writing, but it doesn't.
Yeah. So, I mean,
other than if they are in possession of the tax roll.
Yep. So they could just march into the local treasurer and say, I want this split. And the local treasurer has the right to split it on the spot. But you might get a phone call asking, hey, can you help me on this? and we're probably gonna help them when we get time to help them, because that's what we do. Right? Anyone?
Yes, and I've received one as late as so this is after the first installment was due. I received one in I think May or June, a little while before the second installment was due, and they were late, and they still wanted it split up.
Oh.
We helped them. We did it. But they come in. That's the latest I've ever gotten one and that was this year. But they come in all over the place.
Okay, I'll stop sharing now. There we go.
Thank you.
And okay, I'll pick up where I left off here. One of the other questions that we get: when, where, and how do I pay my taxes? It's a valid question. At least they want to be on time and give it effort. Many of us are in charge of beginning a new tax year in our records database, and it takes time. Some software takes 1 second per record to copy and roll into the new year's database. And if you do the math, it could take several hours. So for example, my county, which is Jackson, has about 27,000 records, and it takes about 7.5 hours to roll over the new year. I really prefer not to have everybody or anyone in the database. And I guess I didn't know any better, and I was just kind of trained that you can do that on the beginning of the tax year. And that's fine, I do. And so I come in on January 2nd, and I click a few buttons, and then I walk away. And the next day that we work, voila, it's done. It's wonderful. So it's a little bit of juggling and orchestrating, but it's very possible. It's very doable because I've done it. Yes. We also provide an export of the assessment the work roll to the DOR. They like to have that in the beginning of the year. Not really sure what they do with it. They just have it. But I'm sure it's important things and maybe used for checks and balances. So we're in March. Recorded documents may slow down, thank goodness, and we could use this time to catch our breath. Assessors are very busy. Some municipalities might be preparing for open book. We're importing assessment data to prepare the assessment rolls. Many of us use this time to catch our breath, restock on supplies, which we might need for the remainder of the year. You'll begin to see the life coming back to some of the listers. Maybe we'll comb our hair, brush our teeth. We might escape on vacation. We might tend to some house cleaning and filing, check in with other departments, other listers, return emails, and finally follow up with maybe a title researcher or an attorney, which had to be set on the side burner as we push through the last few months. So during that first part of the year, thank you so much for your patience. If you're not a lister and you're on this little nice chat, thank you. We appreciate it. April through May, spring has sprung and the transfers are blooming again. And we continue to make ownership changes, inspect documents, call for corrections if needed. We may be preparing for open book and border review for our municipalities. Assessors should be turning in assessment work rolls steadily, and we may be providing notices of changed assessments, preparing the final assessment rolls. We cross-reference our data and double-check our numbers with many different sources such as DOR and municipalities for TID-TIF districts, as well as DNR for any kind of forestry totals. May through July, the majority of municipalities have completed their border review unless there's a reval. And after verifying that our totals still match, the assessor and municipal clerk, we may file the statement of assessment with the Department of Revenue on behalf of the municipality. and will export a final assessment roll to the DOR. So I say that because sometimes, as I said, there's other fingers in the pot, and depending on software, some parcels might just accidentally disappear. And it's always good to go through your assessment roll, and speaking about technology and software, and make sure nothing was accidentally deleted. Nobody purposely deletes parcels. Nobody. It's a lot of work to get them back. So just, you know, double check. And if you just have nothing to do one day and you're done cleaning your desk, just double check. Go ahead. It's gonna probably help you in the end. It's better to catch it before tax time anyway. It's kind of a lot of work. Not saying that's ever happened to me, but okay, August through October. Revals are usually submitted by now, and all assessment rolls should be completed at this time. Unless you're Grant County, sorry, Tammy. Oh. Any changes to DOR tax bill backers have been released. And a tax bill backer, for those who don't know, you have like the front of your tax bill that says all the amazing stuff about where your money's going when you do pay your taxes and your final amount. And then you flip it over and all that really tiny writing that's very informative about the whole process and the DOR and how things are figured. That's the tax bill backer. It changes sometimes, and we have to keep up with when it changes, because sometimes, you know, we're in charge of ordering the paper with that new tax bill backer before we print the bills. So you have to allow time to order from your printer if you are going outside of your county or municipality, and make sure that you allow yourself enough time to get the paper to print on. Okay. All right. So the manufacturing assessment roll is released in the later part of October, and we will be entering all the assessment data and again, making sure we balance. Some of us might need to kindly remind municipal clerks at this time to make time in their monthly meeting for the budget and levy meeting and the hearing in order to prepare for November. And some of us may be sending a supply request letter to assessors in order to plan for the next assessment year. Some of our assessors request a plethora of forms that most of us or some of us take time to print off, staple, put together, and hand over to the assessors. Most of them, all of them are online. But some assessors really like to have that paper, and that's okay. All right. November and December. All right.
April, we've got a few questions, and we're starting to run a little short on time, so I'm going to go ahead and interrupt you. I apologize.
Yeah, go ahead.
Okay, so one question from Trina. She'd like to discuss transfer by affidavit. Specifically, her questions, what are others seeing in regards to recording of transfer by affidavits, but based on the context of a little conversation after that, it seems like the question's a little bit geared towards one, value, or is anybody seeing regulation on value, or do any of your offices regulate value? And then the second seems to be multiple grantee situations on. So anybody want to take a crack at any of those?
I'll talk about the transfers by affidavit. My assumption is the question was in regards to the transfers by affidavit of property 50,000 and less. And again, my response on the chat line was, I see that a lot, but what I see a lot of is, you know, they're taking the value that they determine they can use that from the tax bills or something, the assessed values. So when you're talking, 100 acres of ag land, it's not an appropriate use of that form. The problem is there's no regulating that form. So, it's a little hard for us, I think, as listers to say you can't use that form. I'm not going to update our records based on that form. But I do try to point out in those circumstances to whomever drafted it that, this probably isn't an appropriate form. Could it come back on them someday? I don't know. Possibly. It's probably not the correct way of handling an estate or something. So, it could come back on them, but that's the misuse I see of that particular form.
So, and I'll speak. I just had one a couple weeks ago that was granted to multiple grantees, and we've had some discussion on that in the past. And my opinion is that is not the intent. That the intent is there is one affiant who then is responsible to transfer it to the rest, and that seems. It's not explicit in the statute, but it is certainly implicit. Do you guys have any thoughts on that?
Yeah, I'd agree with you on that. I know, and it's been a while since I've heard somebody from the title industry speak on that subject, but that was always my impression from speakers we've had from the title industry is that the affidavit's not necessarily transferring to anyone in particular, but it is allowing them, as you say, to settle that estate and transfer it as, representing, that person. So I would say you're right. I don't know how it gets transferred to 5 different people.
They had 5 people sign as affiants.
I suppose, like you say, it's not clear from the statute. So, okay, so it will take 5 people to transfer it at some later point. But it works out the same way, I guess.
Right, and as you alluded to, it's not black and white. So in this case, I let it slide, and if there's a problem, they might have to deal with it later in court if somebody comes back on them for it. But that's honestly, that's one of the things that you'll find different between a lot of listers is some are going to say, nope, that's for the courts to deal with. And the lister has to make a decision on that immediately, even if it is for the courts to determine. They have to choose whether to reflect the document in the records or not, even if it's not very clear. And sometimes the choices are different.
Yep, I see from the chat that Trina's question was in regards to what you are experiencing, conveyance for multiple grantees. And again, my impression is that form's not really the conveyance. The conveyance should happen afterwards.
So when I was a brand new lister and I didn't know as much as I know now, thanks to an attorney, a guy came in and said, my parents passed. There was a sliver that was dropped off of their estate. Can I just transfer this by affidavit? And I'm like, So I walked up to the Register of Deeds and discussed it. And he filled out the paperwork and transferred it to himself. Well, he had siblings. And I got chewed up one side and down the other from this attorney. What gives me the right to transfer any ownership and play attorney? So yeah, that's what I was explained to me, is that the TOA or TBA, whatever we decide to call it, is transferring the authority to a group of people or the person in order to elect that person to have the power to then take care of the rest of the stuff that needs to be done.
Yeah, I agree. And you know, again, I don't know that it's up to us to police that. You know, whoever's signing that affidavit should be taking the responsibility and whatnot to do what they're actually supposed to be doing. You know, so we don't know that. So I don't know how else you could or would handle it. If somebody wants to dispute it at a later time, yeah, go ahead and do it.
Right, and in my opinion, even though they don't have that, they don't maybe have the ownership necessarily, the transfer by affidavit to me is the same as a transfer for tax purposes, because that's the person that's going to want to get the tax bill.
Yeah.
It's a tricky question. Well, let's move on to the next. Let me see here. I had a question about a subdivision. Let's see here. I have a large subdivision that applied an interest of ownership in the outlots to 200 plus lots in the subdivision. They sold part of an adjacent lot to the homeowners association for part of the walking trail that was constructed on this, mostly on the outlot. How would you list the new adjacent parcel? So is the adjacent parcel the walking trail parcel? Yes, okay. So how would you list the new walking trail parcel? And she says that she believes the intent was to attach it to the outlot. However, the ownership is not the same. I'm confused by the question, honestly. So let me see.
So if I'm understanding it right, the adjacent lot is not part of the subdivision. It's not part of the outlots. It's a separate parcel. So
actually, the adjacent lot is actually a part of the subdivision. It's lot 54, which was supposed to be used for business purposes. It's zoned incorrectly to begin with. Then the adjacent outlot is, each individual lot has a percentage of interest in, I'll say, via swampland, and then they have a walking trail through this. Well, when they constructed the walking trail, part of it went on lot 54. And so now, the way we have it listed, we list a percentage of interest in ownership in the outlot with each individual lot. Now I have a new deed for this part that's on lot 54, the part where the walking trail is, to deed it to the homeowners association. So.
So you have a current owner for lot 54, correct?
Correct, and they deeded that little portion of the walking trail to the homeowners association. But the individual owners already have a percentage of interest in the adjacent outlot that I presume they want it attached to.
I'd be curious to see how many lots are in that subdivision, how that
Over
outlot
200.
has been 200?
Over 200.
Over 200. And has the interest in that outlot actually been conveyed with each of those lots, or is there some other instrument that is giving that or claiming that? We see a lot of times, we'll see a developer's agreement or something that says it's the intent for this outlot to be owned by each of the lots owners in a percentage.
Yep, that's how it is.
Go through with any of the documentation for that ownership. So if lot 22 sells and deeds just says lot 22, it makes no mention of their interest that they are receiving in part of that outlot. So that's one thing that I find in those types of scenarios, is that it's not really, the ownership is definitely trickier than that. But in this case, if it's as simple as the outlot and you have it listed for over 200 owners, and there's this part of lot 54 from lot 54 deeding it to the homeowners association, I'd split that part of lot 54 out, list it to the homeowners association. I would not attach it to the outlot unless you had, 200 deeds that showed that each of those, I mean, obviously it's different ownership than the homeowners association. And
my other issue is that if I list it, put a parcel number on it, and then nobody pays a tax bill, then we're going to get it back.
Well, the tax bill should be going to the homeowners association because
Right, but
they're
what
the
if they
ones
don't
that got a
pay it?
deed for it.
But what if they don't pay it?
It-
Well,
Which
then
I've
it goes on,
had.
in 3 years, it goes on foreclosure then.
Exactly, but we don't want it.
You don't want a sliver of a whole lot of trail in a subdivision.
But there's really nothing you can do about it. That's the latest deed on record.
Right.
Well, unless your subdivision ordinance says you can't split a lot of a plat without a CSM.
Oh,
I
yeah,
mean,
they
that's
called about
tricky.
that the same day they recorded the deed, so they're already 3 steps behind by doing the deed first before even calling and asking how they wanted it done.
Is this subdivision in a township or is it in a city and village?
Township.
Okay, so then does that township have a subdivision ordinance or is it all tied in with the county subdivision ordinance?
I believe it's all county.
Okay, so then first thing I would be doing is I'd be looking to see if that meets the county subdivision ordinance, because in Trempealeau County, they would have had to resurvey lot 54.
I already know it doesn't, because they, like I said, they called zoning on Friday and that's when they recorded the deed. And so they didn't apply themselves to how they were supposed to go about, because it has to be rezoned even to be able to transfer. So it's.
Yep, so when I have violations of the county subdivision ordinance, I won't even put it in the tax roll until that's corrected, because it might change.
Is the reason they did this whole thing, you said, was because they accidentally built the trail on the other lot?
Correct, yeah.
They should have just granted them an easement over it and been done with it.
I agree, but now I'm stuck.
Yep, I actually, if it doesn't meet the ordinance, I wouldn't even list it at all until it meets the ordinance.
So Nick, are you saying that some years you will have deeds that you have not processed because they don't meet ordinances that you have in your county?
Correct, yep.
And for those of you who aren't familiar, this is a great example of how we all can do something very differently in each county.
And Britta, the reason why that is because a lot of times they'll divide property even without a survey, and that very well could change once they do get it surveyed to meet the requirements of the ordinance. And I don't want to be changing, people's property and stuff like that. So I like to just hold off on listing it until it is corrected.
That's probably what I'll end up doing. Thank you.
Brannick, nobody can hear you.
Oh, I'm sorry. I have my little mute button on my mic. This is one that is very different county to county. And in Monroe County, for example, we view any transfer, even if it's illegal by ordinance, as still having taken place, and we will reflect it in the tax roll and let somebody, in this case it would be zoning, we would inform zoning and let them deal with the aftermath, because it happened anyways, and it just has to be dealt with. The ownership has changed, whether it was legal to do so or not. There's still a document that changed the ownership. That's our opinion and interpretation.
I'm just going to jump in here. When we wrote our land division ordinance in 2019, we specifically put in a clause that I don't have to list it if it's in violation. So that at least gives me some backing when I don't update my listing. So we wrote that in there specifically for this purpose, because otherwise I would list whatever, because yeah, it happened. But we discussed this and decided that until they fix whatever it is that they've violated, that I don't have to list it.
And if that's a really good idea, if that is the policy you want to follow, it is probably a better idea to get that in an ordinance versus not. My opinion, anyways. Looks like we have 5 more minutes, and I don't believe there was any more questions on this. So do we have one more question to go over, Nicole? I think we have time for one more question.
Yeah, we could throw one more in there. This one's kind of related to surveys, certified survey maps and PLATA surveys. So the question is, what is the main function of a CSM and of a PLATA survey? And then what are the differences?
Yeah, I guess I'll take this one. I was hoping to get to the next one. That's the one I really wanted to talk about. I mean, a survey is a survey is a survey. You know, there's generally the same requirements to do it, the same accuracy involved. It's just a certified survey map is typically used for dividing land to create a new lot, you know, where a PLATA survey can be used for a number of different things to define existing boundaries, the transfer or sale of adjoining properties without creating a new lot. But I mean, generally speaking, they're the same and the survey requirements are the same. I know I've heard people say, well, it's just a PLATA survey. It's still a survey, still a valid survey. So anyway, that's my thought on it.
Thank you, Dave. I think Dave wanted to take a crack at the next one as well. So let's go ahead and move on.
Yep. Nicole, you want to read the question?
Yeah, I think this one's actually a good one. So shoreline parcels along the Great Lakes, are they treated differently than inland lakes as far as waters of state and assessment? It was recently brought to our attention regarding a parcel along the Bay of Green Bay that was set up as a 40-acre parcel per the original government survey. However, the GIS today shows as 20.5 acres. The water is very high right now, and per aerial photos, we would believe that since the current owner purchased in 1991 is when the water has since risen. So I guess the question's kind of in there about how do you list acreage?
Yeah, and seeing how we're running out of time, and this is one of those controversial subjects between listers that we may not agree on, I'm going to try to talk all the way through this so nobody can refute what I'm going to say here. My opinion is, you know, I think it makes sense to you know, this snapshot in time, this is the size of it, you know, to the best of our abilities. It's clearly not 40 acres anymore. I think we have the authority, if you will, to make those decisions on what acreage we're going to recommend that the assessor use to value the property. And to say it's 40 acres makes no sense to me. So, you know, my personal opinion is, you know, that we should update that acreage based upon the best available information we have today. And a lot of that depends upon how confident you are in your mapping, you know, your mapping data. The other point I want to make in that is, if you look at the original government patents, usually they do say more or less on the acreage. So, you know, I always kind of use that as an out, and we're at 11:59. So
that's okay. As long as anybody we are actually going in, I'm sorry, we're actually going into lunchtime at this point. So we actually can keep this discussion rolling a little bit longer on.
Wait.
There's an hour before the next session. So if you need a little bit of time, or if you want to abandon the cause, you're welcome to. Just a quick word before, so our next session is at, I believe at 1. There's the Talk About It lunch at 12:30, and from now until then is break time. I believe we are probably going to talk a few more minutes here, anyways about acreage. If you want to stick around and listen, we're going to have a little bit of an acreage discussion, it sounds like.
Before we go on, could we just make a call out to the education committee and what the purpose again is of the educational session?
Yes. Thank you to the education committee for putting this together. The education committee puts together some material for our ASM every year, and this year we decided to share it with the WLIA group as well, to let others besides listers know what the heck we do. Does that cover what you want, Britta?
As well as just during our normal ASM to our members, if they have any questions, we have Bitrix. We are an association. We are here together to help each other out, and the education committee tries to bring educational topics to the association every year in the form of, usually we get to play fun games and activities, not this year, but if you have questions on how we do what we do as listers, we do have a manual. It's sort of like our standard operating procedure, our standards. This is how we operate. This is what we do. This references our statutes that we as listers do our work to. We, obviously reach out to each other if we have differing opinions, and we kind of see, well, how do you do it over in your county? But ultimately we have to back it up somehow with our own county policies or other things. But that education session helps, new listers and old listers see how everybody's doing things. So I appreciate that, their educational sessions get to bring some fun and activity and information to our association.
Thank you. Thank you, Britta. I will continue on with our slight acreage discussion. One thing I'm going to point out is that 7009 statute does give it gives the county board the authority to determine acreage of parcels greater than 1 acre to the real property lister. So actually, real property lister can and should have final say on acreage short of a survey.
So to go along with what Dave had to say, because I've ran into this quite a few times with the Mississippi River and the Black River changing quite a bit, and it's all government lots. So to remain consistent, we've always held the acreage based on that original government survey. So if government lot 7 says 40 acres or 35 acres, we hold that, even though we can go back through all our different aerial photos and what that land's changing. What we advise the assessor to do is to use our online website and stuff like that. And if I list a parcel as the acreage on that original government survey for whatever that government lot is, doesn't mean that they have to tax that parcel to that acreage. They can use the acreage tool on the website. So if I have it listed for 40, and if they measure the land above the water as being 23, they can assess and tax it for 23 acres. And we can create a report that shows that this many parcels doesn't have the legal acres balancing to the taxable acres, but we can remain consistent on the reasonings why that is. And that's how we go forward, because the deeds through time state government lot 7 of this section, town and range, and you go back to that PLSS map and it says this acreage, and that's kind of how we handle it.
Yeah, that's another good way to handle it. And I've got one question for Dave. I actually generally agree with Dave on acreage. My one question is that we do aerial imagery every 5 years. What's saying that the level of the lake is the same in 2018 as it was in the 2015 imagery? Dave, your mic's off.
You didn't want to hear what I had to say, Nick, anyway. So I guess my response to that is, typically when I've dealt with those situations, it's been in response to a particular question or issue at a certain point in time. You know, obviously, you know, anything on a water body's changing daily, you know, some imperceptible ways. So, you know, unless there's a good reason or a noticeable change, I typically wouldn't go back and update that. We do area calculations, you know, on like a yearly basis, and compare them to our assessment roll acreage to see if there's any great noticeable differences in the way we have them mapped. So sometimes in your, you know, if we've updated the hydro layer for a newer aerial, it may come out, but you know, chances are it won't, because we don't update the hydro layer quite that often usually.
And again, this shows a good example of differing between counties, and there's really nothing black and white that says how we should all be doing this, as long as a lister can remain consistent and go from there and have some type of reasoning to back it up.
Right you are, Nick. And again, I'll push back to that. The lister has the authority to determine the acreage. What the tools they use don't have to be the same from county to county. There are counties, and this applies to all parcels, because parcels are broken up into 40-acre tracts of land, more or less. And if you have good GPS data, you're going to find out real quick that none of those parcels are actually 40 acres. Mm-hmm. And if you have really good GPS data, I would say that you are within your authority to update based on that GPS data if you choose. I would not say that you're wrong to do so.
The assessor also has the option to not, although it never really happens here, to not match our acreage, and maybe a hybrid approach to what Nick and I are talking about. I do kind of the opposite of what Nick does. I update my acreage in hopes the assessor is going to match my acreage, but sometimes I will put a note in the legal description that, you know, per government survey was 36.2 acres. Now, when you start chopping up the government survey lots, it's a little difficult to do that, but
well, the other problem is too, is like ours are right on the county boundary between us and La Crosse County, so La Crosse County's got to be doing kind of the same thing we're doing. And so what we did is we had our county surveyors figure out where that meander line is through there, because that's what the government lot lines are kind of go to, and then that's why we hold that acreage. But in like a case where that body of water, say it's not between counties, is shifting, so we do our aerial flights every 4 to 5 years. Am I going to remember to go back through and look at that? And what happens if I'm not the lister? Is the next lister after that? And if somebody says, well, how come my acreage didn't change this year? I'm on you guys' county website and I can tell it's different. And so it's just, you know, you've got to pick your battles, I guess.
Yeah, well, and again, like I said, a lot of times for me, it's in response to a particular issue or question. So if somebody would come back, I always tell people when they don't agree with my acreage, well, look at it on the aerial. Does it look like it's covering your property? And if it is, then I'm pretty sure my acreage is good. But I have no problem re-reviewing that stuff if somebody does have a question.
And in my county, I have no problem saying get it surveyed, because I don't want to decide.
If they want to get a survey and prove that acreage, that's great.
Also, I try to do whatever doesn't make me cry or get yelled at. So
I think that's a good ending point. We'll go ahead and wrap up and let everybody go their merry ways. Thank you all.